Welcome, everyone, to the Lucky 7 Construction Contract Must-Haves for Owners. I'm Andre, your host for today's program. Before we begin, here are a few housekeeping items about your experience. Materials are available to download under the Supplements tab. Questions can be submitted under the Participation tab. Also included is the discussion board. That board is not monitored by the staff or speaker, and comments are public. Finally, we invite you to take a few minutes after the program to share your valuable feedback. The link to the survey can be found under your viewer window. I'm pleased to introduce our speakers today, Jackie Greenberg Vogt and Marie Groeneveld. I'll turn the floor over to them now for further introductions.
Good afternoon, everyone. I'm Jackie Vogt, and this is my partner, Maria Groeneveld. I'm the chair of the Construction Law Group here at Mandelbaum Barrett in Roseland, New Jersey. We represent owners, contractors, designers, and developers in all aspects of the construction process. So we do everything from assisting with contract type selection, project type selection, hiring, negotiating, and drafting agreements with designers, contractors, construction managers, and we also handle disputes that arise during the construction process. We counsel our clients to have in place good dispute resolution mechanisms so that problems can be solved and addressed during the project so that they don't turn into disputes later on. We provide in-progress construction project counseling services to try to help alleviate those kinds of risks. But in the event of a dispute, we also handle mediations, arbitrations, and trials of all construction-related disputes. We're here today to talk about what Maria and I view as the must-have contract provisions for owners. Your typical construction contract, depending on the size and complexity of the project, can go anywhere from, I don't know, Maria, what's the shortest one you've ever seen? 3 pages or so?
Yes. Well, I mean, I think you can be in a situation where a contractor will provide an owner with something that really looks like a purchase order.
Absolutely.
Right? And they'll say, here, don't worry, you can work on this.
I use this one all the time. So our clients come to us in that situation and we say, no. There are certain key provisions that we are pretty certain the contractor is not going to have included. And these are the things that we're talking about today. And again, ranging from a 2-3 page document that looks like a purchase order to a 50-page document using AIA forms or forms from any of the other providers that are out there that can have a 20, 30, 40-page contract plus 50 more pages of general conditions and everything in between. But one of the first things that you want to think about when you're working with a new construction contract is, I don't know, the contract type or the project type, how you want to set up the project. Is this going to be a design build project? Is this going to be a gross maximum price contract, a guaranteed maximum price contract? Is this going to be time and materials?
Some of those questions, I think, get answered depending on where you are in the project, when the contract has to be made. Certainly when we're talking about like residential projects that can get up there in the millions and millions of dollars, you probably want to be at a fixed fee in that type of project. Development projects, sometimes though, they're, people are bidding on the project, they're designing at the same time, and they want to start getting their contractor in place. And a lot of times in those situations, you may not be able to go with a fixed fee because the drawings might not be done.
So let's pause here and talk about what a fixed fee project is like. That's when the contractor takes a look at your specifications, your drawing, what have you, and says that this is what I'm going to build this project for. Whatever that number is, no more, no less, this is what you're going to pay.
Right. So any savings that might come along to the contractor in terms of the price of any of the, construction supplies, that kind of thing, those will all benefit the contractor, because you as the owner, when you sign that fixed fee contract, have said, this is what I'm going to pay for it.
So that kind of a fixed fee contract can still be beneficial to the owner because it does provide certainty.
Yes.
You know you're going to get a completed contract for that price. And the contractor is eager to do that type of contract as well, because there are opportunities for either value engineering within the project, or perhaps this particular contractor has a related subcontractor within his organization that the contractor can sub out a certain trade without having to mark it up for overhead and profit.
Right.
So there might be some savings there. So again, a fixed fee contract can work really well for both an owner and a contractor. But in another scenario, you might want a GMP contract. Maria, where do you like to advise clients to use a GMP?
Well, the GMP is the guaranteed maximum price. And in that, the parties have said, well, this is what we think the overall price of the contract is going to be, but sort of the specifics haven't been set forth. And what happens is as the contract gets more solidified and you know what the price of things are going to be, the fee is going to be a percentage of the cost of the work and the insurance and the overhead. And that's how you determine that. And where I've seen it used is in sort of bigger projects where they want to get bigger construction companies online to do the work, but they might not have all of the drawings done. I can think about a hotel project that I worked on where the restaurant wasn't fully done and they were waiting on those drawings to come in. They had most of the room drawings, they had the bar on the roof, but like those types of things, the contractor can't sit there and give you a fixed price if he doesn't have drawings to work with. So they had to go to this model. And then in this model, when savings come up, because, maybe they thought the complexity of the restaurant drawings were going to be more than they actually turned out to be, any kind of savings can be split then between the owner and the contractor. So it gives the contractor some motivation to save on things. But there is there's not the certainty in the fixed fee that you have.
What happens in a GMP project where there's an overage?
In terms
of cost?
Well, I mean, sometimes you're going to have a change order based on that, because, sometimes the cost, is the contractor going to eat the cost? Generally
not likely.
Generally not. And so what I've seen is, okay, well, you guys wanted this stone and it's now this much more. So, we want a change order. And the contractor is probably not going to come out, behind doing that.
The contractor never wants to come out behind. I mean, what's the point of doing this?
Right.
We saw this a lot, I think, during COVID and in the aftermath of COVID with construction projects, where there were GMP contracts in place and owners were very hot and bothered. Well, wait a minute, I have a GMP. I should never have to pay more than that maximum price. And the contractors were saying, well, because of supply chain issues and everything else that happened out in the world at that time, this project's going to cost me so much more. I can't get the materials. They take longer. So there's increased costs
delays.
and delays. And there's a school of thought that said, well, the owner has a GMP, the contractor is required to honor that GMP. But then the other school of thought is you've got a contractor who's going to lose money on a job. So that puts the contractor in the position of saying, I can either complete this job and lose a lot of money, or I can walk off the job and at least I will expose myself to the risk of breach of contract, abandonment of the job, but at least I won't go out of pocket tens and hundreds of thousands of dollars trying to complete a job for a price that is going to put the contractor out of business.
Yeah, my experience with the GMP has really been that cost overruns then end up in change orders. It's not so much that the contractor then says, oh, right, we agreed to this GMP. I just think that's how it gets handled.
I have a case where a client of mine was the owner developer of a $55 million residential complex. And the contracts were signed pre-COVID. And the contract said that the contractor is required to have all subs lined up and signed by a date certain. And the owner's thinking on that was that not only would the contractor be committed to a guaranteed maximum price, but all subs would be on the line for having to committed to provide all of the trades at a certain price. Well, lo and behold, the contractor signed this contract agreeing to have all the subs online, but then actually didn't do it. So COVID comes along and the contractor can now not get his or her subs on the job to do the work at the price that the contractor had guaranteed to the owner. And boy, the owner was miffed. And the owner had to go out of pocket to get the work done or face delays. And now we're in litigation over who's going to bear that cost. And the contractor at some point during the COVID process did ask for a change order, a $3 million change order. The owner said no. And so here we are years later in litigation. It's a lose-lose situation.
Right.
Because you're constantly fighting over who should have to bear the risk, which brings us back to why we talk about construction contracting in the first place. It's all about risk allocation. You know, the whole point of construction contract is so that ahead of time, the parties know who is at risk for what. And these various types of project structures that we're talking about, these are the considerations that the owner and the contractor have to think about before getting started.
Yeah, and typically the guideposts you want to look at too is which party has sort of the direct control of the issue that you're dealing with in the contract, right? That party bears the risk or should bear the risk. And then when there's a party that doesn't have control, like it's not something that's clearly the owner can control that or clearly the contractor, then it's really who can sort of prevent a loss in that area. And then I guess sort of the default rule, if there's kind of no one to figure it out, often it gets put on the owner to bear that risk. So those are sort of the general guideposts that you have in a contract when you're thinking in a construction contract when you're thinking about risk.
Right. And I always counsel my owner clients, you have to have fair contract terms. The allocation of risk has to be reasonable, because if an owner tries to shift too much onto the contractor, then the contractor is going to walk. And if the contractor makes unreasonable demands for change orders, then the owner's not going to budge either. So at the end of the day, the contract has to be fair and reasonable and has to even-handedly allocate risk between the party, as you said, between the two parties as to which party has the most control over that element of risk. And that's how you're going to end up with a good construction contract.
And just on the idea, you've mentioned it a couple times about a contractor walking off the job. That is a frightfully expensive problem, because any contractor coming in, you as the owner are not going to be able to say, I have $250,000 worth of work left. New contractor, please perform $250,000 worth of work. What happens is there's ramp up charges. They don't want to be responsible for what the other contractor did, so they're going to charge you for that. And that $250,000 worth of work that you had left on the contract that you can't get done because there's been a problem with the contractor is now going to balloon into $750,000, $1 million, something like that.
And months and months, if not
Yes.
years, of delay.
Yes.
So I think Maria and I are on the same page here, where we say that terminating a contractor is your absolute worst case scenario, last thing that you try. Everything else, you've got to try really hard to avoid having to terminate a contractor.
And that due diligence on your contractor at the beginning, recommending to your client to do due diligence on the contractor is a very important thing to do, because you know, even running just a quick lawsuit search is helpful, because if you find out that they've been sued several times for failing to finish something, you may not want to go with that person, because that, like, once you get them on the job, you really want to be able to work with that person to the end of the job.
So a quick litigation search, always a good idea. A quick judgment search, same thing. And let's, I'm bringing up a topic that, I wasn't sure we were going to talk about today, is bonding.
Yes.
Prior to COVID, you mostly saw surety bonds on construction contracts in public projects, and public projects in most states require bonding. But I'll be honest that I more and more recommend to my clients to consider requiring surety bonds on their private projects for a lot of different reasons.
Right. Mostly what I've seen though happen is contractors are like, no way, because it's expensive. So then it shifts back to the owner if they want to pay for it.
Which is, I think, okay. Don't be penny wise and pound
Right.
foolish. For the cost, the typical performance bond, surety bond, will cost about 2% of your total project value. That's an estimate. It can be between 2 and 4%. But, for that 2 to 4% of your project cost, you get several things. Number one, you get a guarantee that your project will get done for the contract price, because if surety has to come in to complete a project with you or with your contractor, you still only pay the contract balance, and any overage, the surety pays for it, and then let them fight it out with the contractor, depending on whose fault it is. The other thing you get sort of before that is, in order to get a surety bond, a contractor has to
Yes.
provide a lot of financial information to the surety. So that's a lot of really helpful due diligence, because the surety will determine whether your contractor has a certain financial stability, reputation, experience, resources and assets in the event of a problem. And all of those things do protect the owner. So again, it's a risk allocation mechanism, and it's all about managing the risk.
So I think now we've kind of talked about like the broad strokes of like the different types of agreements you can get. When we get down into the more nitty-gritty part of it, some of the important, terms of the agreement, I would say one of the biggest or most important one is the payment terms. And so typically there's going to be a down payment, often paid at the time of the signing of the contract. And contractors will ask for a very big down payment. And even though it is, say, against the law in New York for contractors to take that money from one job and use it to help finish another job, in reality, that happens a lot.
It happens all the time, robbing Peter to pay Paul.
Right. So sometimes when I come across a contract where they've asked for a huge retainer, like, oh, we want 50% of the down payment up front, part of me, that's the signal like, are you stretched thin on some other contracts? And then I'm making sure that my clients have done their due diligence on that person.
Absolutely. Any contractor that asks a client for 50% upfront, I tell clients to run in the other direction.
Right. So you're kind of looking, I generally try to get 10. Sometimes I'm in the 20 range. What do you typically?
Well, I think it depends on the project, actually. So there's a lot of, just like with everything else that we talk about, there's a lot of different ways to approach payment terms. Depending on the size and complexity of the project, I like to tie payments to milestones, to progress of the work. So again, depending on the project, let's say it is a project that has very big upfront costs. There's a lot of site work, a lot of excavation that needs to be done before the project can start. Then it is not unreasonable to look at your schedule of values. And if you see excavation, there's a big number associated with excavation and sort of concrete work at the very beginning of the project, I would agree to a larger upfront payment because there's equipment that needs to be rented. There's, the cost of excavation can run really high. But if you're doing basically either, a retrofit or a renovation or a project that doesn't require a lot of upfront work before the real work starts, then I might recommend only a 10% upfront payment before the contractors starts work. Then, I've been involved in some very high-end, luxury residential stuff where you've got huge upfront costs for long lead type items, specialty items, custom items. And again, those kinds of things can justify a larger upfront payment. So in terms of the payment terms, as you can see from the slide, the size and complexity of the project does matter. You want the contractor to be able to get on top of it in front of the long lead items. So, but what do you then need in your payment terms of your contract? Well, those provisions need to say for long lead items, the contractor must provide those invoices to the owner, and the owner pay for those custom items or long lead materials based on an actual invoice or some sort of backup from the supplier. So, and there has to be language in the payment terms that the payments that owner provides to the contractor be used specifically to pay for those things. So, that's one of the things that I'll do. Again, on a larger project, I always recommend, you, Maria, also recommend holding back 10% of every payment as retainage.
Yes, retainage is a very, very important thing to have because that is the last payment at the end. And I always tell clients, you want to be the retainage as high as you can get it and hold it to as long as you can. Like you want it at the very, very end when you are completely done with the project, all final lien waivers have been provided, and anything needed at the Department of Buildings, especially like in a place like New York City, has been handled. Contractors are going to fight you on that. I think the standard in the industry is 10% retainage, but that 10% gets reduced to 5% at the time of substantial completion. We'll talk about substantial and final completion in a little while, but I agree
that the owner always has to have something held back from the contractor. It's a
game.
It's a game. You need to have a carrot in front of the contractor's nose to encourage the contractor
to come back to fix those things that,
complete the punch list.
Yeah. And the punch list may be, changing out hardware, small things that especially contractors who do big projects don't really want to spend their time doing.
And I think we touched on this earlier, that a contractor is motivated to front load the payments.
Right.
The contractor wants to get as much money up front as possible. Now, there are times where you've got a contractor who's not managing his or her money very well. They may need your upfront payment to help them finish another job that they haven't finished yet. That's a danger, because then when you get to the end of your project, the contractor, there are times it's very typical for a contractor to run out of money and not have time to finish, have enough funds to finish.
Yes.
And again, they're going to then slow down or stop work on your project and go on to their next project and try to get an upfront payment from them, and maybe use some of that money to finish out your project. Now, all of this is unlawful. This kind of robbing Peter to pay Paul, it's unlawful. Contractors are required, and we have in New Jersey something called the the Construction Trust Fund Act, that requires the contractor to segregate the funds for each project and to do separate accounting, basically have separate accounts for each project, and ensure that the money that comes in for each project is only used for that project. Now, we all know that that kind of mechanism, it's violated all the time.
Yes.
It's standard.
Pretty much everybody.
That doesn't make it right.
Right. So, a question has come in. Can a certain portion of the payment be held in escrow for a period of time after a project has completed to make sure the systems or buildings function as expected?
Okay, well, that's a good question. So the answer is the parties can contract to do whatever the parties want to do. So Maria was talking earlier about retainage. It is very typical for that 10% retainage, or sometimes, like I said, it's reduced to 5%, to be held until final completion and then released.
Okay, so maybe we should talk about what is substantial completion, because at that point you're going to pay your 5%, and what is final completion.
Okay, so let me first. Okay, so the answer to the question is the parties can do whatever they want in the contract. So, but a part of the answer is also that under your typical construction contract, the contractor provides a 1-year warranty on the work. So there's two different things that we talk about for additional work that the contractor does after completion. There is warranty work, which is that all elements of the project have been accepted and completed, but during the 1-year warranty period, something either malfunctions or doesn't operate the way it's expected to. The contractor does have a 1-year warranty obligation, which would require the contractor to come back and fix it, return it to the way it's contracted for.
Typically, money is not held back. Like once you get to final completion in the typical contract, that last percentage of your retainage is going to be paid over to the contractor. But at that point, you want to make sure that final lien waivers have been given, that your architect or your owner's rep has, whichever is sort of leading the project on the payments, has gone through and said, yes, everything is completed. Everything on the punch list items has been completed.
Right.
And you want to make sure, again, anything with the Department of Buildings has been satisfied. So it's supposed to be at that point that everything is done.
And your contractor is, by the way, doing commissioning, startup and commissioning of all your systems.
Right.
So you're going to have assurance at the time that you finally accept the project, that everything is working. So, your HVAC system, whether there's a security system, your electrical, let's say you have more sophisticated systems, if it's an industrial project or something like that, there's going to be a whole period of time between substantial completion and final completion that the contractor is going to be proving to you as owner that the work is complete, that it's functioning the way it's supposed to function.
But what you want to make sure is when you say proving to the owner, it's really proving to the owner's architect or owner's rep.
Or construction manager, whoever.
Whoever you have has to be on site and has to be determining that these things happen. Now, this person should have been on the project from the very beginning, and as payments are made during the course of the project, and those might be monthly payments, sometimes contractors want them bi-monthly, contractors should be submitting a payment request saying how much of the project has been completed. The architect or the owner's rep should be going and saying, yes, I certify that these things are done, that if the contractor is saying that 50% of electrical is in, that it's in, and that, yes, owner, go ahead and pay this because we're ready to go on to the next stage of the contract. I have had situations where architects, part of it is absentee owner living in Europe, huge renovation of an apartment, architect did not come, contractor was saying things were completed and they weren't. Contractor eventually walks off the job, and these people paid probably double for the cost of renovating the apartment. That's after having been through that experience, I know it's really vitally important that you have someone checking these payments.
Owner's eyes and ears. If the owner can't do it him or herself because of lack of experience, lack of knowledge about how to do it, then by all means, you must either engage your architect or engineer, your designer to be your eyes and ears on the project, or hire a third-party construction manager who is your representative, who acts in your place on the project. But what happens if the system that we're talking about, getting back to the question, is not functioning prior to the project completion? Well, then you have a situation that's not warranty. That doesn't fall under the warranty requirements of the contract. That falls under a defective work type situation where the contractor has not completed the work in accordance with the plans and specifications. And in that scenario, the owner is not obliged to pay for the work.
Right.
So again, the architect, the engineer, the construction manager would not certify the request for payment. For example, the mechanical systems, the HVAC, not functioning correctly. So for ease of mathematics, the contractor puts in a payment request for $50,000, which is partially for HVAC, partially for electrical, partially for plumbing. The construction manager, the architect comes in and says, well, you've billed us of that $50,000, $25,000 of it is for HVAC, but the HVAC is not installed correctly. It's defective. So we're going to withhold that $25,000 from the payment that's been approved. And we're going to make the contractor come back and bring that HVAC work to spec so that it is functioning. So that's the way that you hold the money back from the contractor. So it doesn't happen necessarily at the end of the project the way that the question posits, but rather it's something that you keep your eye on throughout the project. And this, I think, highlights the reason why it's important to be watching the project every step of the way.
And those people, they all cost something, but it's kind of like the surety bond.
Mm-hmm.
It's like worth paying for, so you have eyes and ears and don't end up in a situation.
Right. So getting over to, we're required by the New York regulations for CLE to give the following statement. So we're going to do it now. In order to comply with New York regulations, attorneys looking for CLE credit in New York will need to be able to provide a code. This code is not intended for the West Legal Ed Center audience, either live or on demand. I will read this code twice and only twice, and cannot repeat it or email it to you, so please make note of it. The New York State code number is G for girl, a second G for girl. The numbers 33213-103023. Again, the New York State code number is G for girl, another G for girl. The numbers 33213-103023. So please make a note of it.
Should we talk about some other important parts of the contract? One of the things I would say with your payment terms, just quickly, is that you need to get a lien waiver. So do you want to talk to them about what a lien is on a construction project and why that can be so detrimental?
Okay. All 50 states in our country have lien laws that protect the contractor to ensure that the contractor gets paid. A lien is a claim of interest in the title to a piece of property, or in the case of doing work on a leased property, the lien attaches to the lease. It is a property interest. It is recorded with the clerk in the county in which the property is located, and it does it does create a cloud on title.
Right. So whoever owns the property is not going to be able to sell the property with that lien still there. And in every lease, there's a provision that says if you, tenant, are doing construction on the property, and you have to bond over the lien should a lien, usually it says you cannot put one or allow circumstances to arise that will allow one to be put on the property. But if that happens, you have to bond over it so that there's no cloud on the title.
Yeah, so having a lien be filed against the property or the lease is an automatic default under a lease, and with respect to construction financing that the owner has for the project, again, it is an automatic default under most bank loans.
Yes.
So, so the payment terms of your contract should state very, very clearly that before a payment by the owner to the contractor can be made, the contractor is required to provide the owner with lien waiver forms signed by his or her subcontractors, which state that they either have been paid or are going to be paid from this payment, and that they release any claim that they have to file a lien with respect to that payment.
Right. So there are conditional lien waivers that sort of work with payments over time to say that they've completed a certain amount of work and they've been paid for that certain amount of work. So then if they were then to go file a lien against the building, you can say, hey, they signed this waiver, I paid them for the work. The final lien waiver is the one where they say we've been paid in full and we have no claim, and we waive our right to file any lien against the property. Again, the owner's rep, the architect, can help get these documents, but I always like in my contracts to actually include the sample lien waivers at the back.
Yep.
As exhibits so that everybody knows what's expected to come with the payment requisition. A question has come up about what a punch list item. What is a punch list, and is that part of the contract? Which might be a good segue into, I think we might have not talked about, but there are many different parts and exhibits to a construction contract. And I think it's important that we get them all there. So
Absolutely, that's I think we have that in one of our next slides.
Yes.
We've talked about most of the, okay, identifying the contract documents is really important
Yes.
for construction contracts. So first of all, we're going to answer your question, but just this is sort of a little bit of a lead into your question. So the construction contract in and of itself is not the only document that governs the construction project. Typically, you have an agreement of sorts that lays out some of the general terms, how payments, who the parties are, what the name is of the project. But the agreement also identifies all of the contract documents. The contract documents will include the drawings, the specifications, the form of lien waiver,
Schedule of values.
schedule of values, the construction schedule for the
Yeah.
work,
Yeah.
and then the general conditions. Sometimes the general conditions for the project are included within the agreement itself, and sometimes they're a separate document. But it is incredibly important for there to be very, very clear definitions in the construction contract of what the contract documents are. Let's say your agreement refers to a drawing, for example. If that construction drawing is not identified specifically by
Right.
revision number, for example, the contractor could end up building
The wrong
the
thing.
wrong thing. And the owner needs to protect him or herself by making sure that the contract specifies which revision number of the drawings is the applicable drawing. And also identifying drawings within the construction agreement helps also with coordination of trades, because you need to know revisions, you need to know how work follows on to other work, so that you don't end up with a trade contractor putting something in only to have another trade cover it up,
Right,
or interfere with it in some respects. So as we said, the most common contract documents are the construction agreement, the general condition, the specifications, the drawings, the scope of work, the schedule of values, and the schedule. Also, the construction agreement identifies the order in which these documents control, and that avoids conflicts.
Right, because there can be, they can have one thing says one thing and another document says something
Right.
else. So the order is supposed to dictate which controls
Right.
in that situation. But the punch list, like, there are other documents that go along in the process of the construction, such as change orders and payment requisitions. The punch list is one of them. They're not part of your contract, but items that get developed over time. The punch list is usually created with your architect, your owner's rep,
And your
the
contractor.
owner. They're going to go through the project and point out, well, the hardware wasn't put on here, or, we need to finish the electrical plates. It'll be a list of smaller items generally.
So the punch list is typically created at the time of substantial completion. Substantial completion is defined generally as the point in time when the project work is completed and advanced to the stage at which the project can be used as intended. So the hospital can take patients. The residents can get a certificate or a temporary certificate of occupancy. A school, students can come in. So it's the stage in the work where it is mostly complete, except for smaller, unfinished, incomplete work. Those items become the punch list. And the punch list provides the checklist, so to speak, for advancing from substantial completion to final completion.
Yes.
We referred earlier about reducing retainage at the time of substantial completion. So the point of this is you've been holding it back 10% through the whole project, but you're now at the point where the kids are going to school.
Right.
So it's not fair to the contractor to keep 10%. It's appropriate to reduce that. Now, again, depending on your experience with the contractor's performance, you may or may not want to reduce the retainage.
Right.
But that retainage, you want to hold it in place. You want to keep it. Somebody asked a question earlier about holding funds in escrow. This is not quite holding funds in escrow, but it's
the leverage.
It's very similar. It's the leverage to induce the contractor to come back and finally complete the job.
Right.
So that's how, this is how the owner protects him or herself from incomplete work. So no matter what, there's always got to be enough in the retainage or the withheld funds that it's enough money that the contractor.
It's motivating enough, but not punishing enough.
I think that's an excellent way of saying it. It can't be so little that the contractor says, not worth it for me to come back for that much.
Right.
But also not to punish. Again, the concept of fairness in contracting, that's how you avoid disputes. If you have the power as the owner to dictate really onerous clauses. If the contractor's hungry enough and the owner is strong enough, you have the power. When I first started practicing law, I will never forget the first partner who I ever worked for. He said to me, Jackie, the person with the money is the one who makes the rules. And I've never forgotten that. And it's true. That's where the leverage is, the money.
Yes.
But if you
play too many games with a contractor, they also need to be paid, because that's how they can keep their business going. And if they find it to be too difficult, they may, again, you don't want them to be too frustrated about it.
We have here, I did want to put up on the screen, if you can see through the PowerPoint, and I apologize, Maria and I just talking, we're not necessarily putting the right slides at the right time. But we have here the definitions of substantial and final completion. They both are legally recognized terms of art in the construction industry, and they both have consequences. So it's really important that these definitions be included in your contract.
Yes.
So substantial completion, as we said, when the project has reached the point in the construction process where it can be used for its intended purpose, even though there may be some minor work remaining. And that's the punch list. Final completion is the point in time when all work is fully and finally completed. And here's the important, in accordance with the contract documents, and the owner has accepted the work. Accepting the work is another legally significant term, because once the owner has accepted the work and the project, the control over the site switches from the contractor to the owner.
Right.
The obligation to release final payment occurs. And that's also, again, you can contract for this, but do you feel that the warranty period should begin at substantial completion or final completion?
I try to get it from final completion, because that's when you've accepted the work. So you want your year to run from that date. It's nearly impossible to get more than a year in.
It's just that's the state of the industry,
yeah.
Right? I mean, that's the industry standard.
Right.
So because there is something called the statute of repose and the statute of limitations that applies with respect to disputes on a construction project. So a statute of limitations, you may or may not be aware, is the statutorily designated time frame that two parties to a contract have to bring claims against each other. In New Jersey, it's 6 years. What is it in New York? Is it 3 years in New York? And these are the kinds of things that vary state to state. But there's something else called the statute of repose. And the statute of repose is it's different. It's not the time within which to bring a claim, but it's really It's based in the common law, where if a contractor performs on a project and then something goes wrong 10, 15, 20 years later, and the owner wants to go back against the contractor, well, the common law, and actually this probably comes from our American roots in the British law, that at some point that the contractor is entitled to rest easy. That's the term repose,
Right.
to rest easy, to know that something that they did so long ago can't come back and haunt them anymore. So the contractor can't be held responsible for something that he or she did so long ago.
Right.
So again, the legal significance of substantial and final completion and why they're legally significant.
So another thing we can talk about, another part of your contract is going to deal with changes.
This is a big one.
Changes.
Where's our changes stuff?
Changes in the work do come up.
There we go.
And there's sort of like different levels of changes. Ones that might be very simple. You might come in and say, I don't like this white paint. I want it to be another white paint. And they'll just write a directive. They call it a change directive.
Construction change directive.
Yeah, so it's not really going to change the cost of the project or whatever, but then everybody knows, like, okay, we're using this different color white on the project. But there may be something bigger that comes along that really is a big change to the project.
That changes either the time that the project's going to take or the cost. So it's incredibly important for your contract to have a very carefully worded and thought out changes clause. A change order is a written document signed by both the owner and the contractor, and if there's a designer, by the designer as well. The change order actually becomes a part of your contract. And what it does is it modifies the terms that you already have in place, and there is typically a drawing, some backup payment information,
schedule,
a writing.
what it does to the schedule, those kinds of things. So it's important that that be addressed, because there will be, especially, I think you see this in a big renovation, say, and contractors get behind the walls and suddenly they discover, oh, this isn't quite how we thought it was. We're going to have to do some changes, some different wiring, different something, and they'll be requesting change orders. So you really want to make sure there's a good process in place for someone to agree to the change order, agree that it's needed, agree that it was not part of the original contract, and to make sure that the owner understands what this is going to do to their schedule and to the price.
Now, buyer beware. There are lots and lots of contractors out there that will purposefully underbid a project.
Yes.
In order to be awarded a project on a bid, and then hope to make up whatever loss that the underbidding may have caused through change orders. So that's why, one of many reasons why it's so important to carefully draft your change order clause. So the language of the change order, it has to clearly identify what the change is. It has to include mechanisms for proper estimations in either time or pricing. And it has to be justified. It has to be as the result of something that came up that the parties were not aware of prior to the original agreement. For example, an unforeseen site condition. You know, you're doing excavation, you allocate a certain amount of resources to clearing a parcel of land for new construction. And in the course of doing so, it could be something as simple as a very large boulder that did not show up on any pre-contract geotechnical surveys, or it could be something crazy. I've never had this personal experience, but I am aware of construction projects where they found Native American burial grounds or other archaeological sites of significance, which bring a construction contract to an absolute halt.
Right.
So a change order will extend the time, increase the price. Sometimes a change order reduces a price.
Right.
If a contractor was being conservative and estimated a lot of boulders, for example, in clearing a site, and then it turns out that they weren't so bad after all, and they were able to do it more quickly or more efficiently than they originally thought, and the change order will actually reduce the contract price. Same thing can happen with materials and supplies, although not so much in this post-COVID world, but let's say the price of lumber goes up or down in a significant way. So your change order clause has to be pretty specific. Like for example, a contractor really does have to give a good estimate for what the lumber for a project is going to cost.
Right.
And the contractor has to honor that. But let's say something ridiculous happens, like with COVID, and the price of lumber increases. So I draft changes clause where a contractor might be entitled to an increased cost for materials, but only when the increase is 25% or more. Regular market fluctuations, the owner doesn't want to have to deal with that. And there's a certain amount of risk that the contractor has to bear, because the contractor, going back to our original point in talking about construction contracts, is allocating the risk to the party best able to handle that risk. And as between the owner and the contractor, when it comes to a price increase on materials, contractor's in a better position to be able to evaluate that risk.
Right.
So let's say with a typical change order, the work cannot proceed while the parties are negotiating whether that change order price is appropriate or that change order time. And there can be disputes about that.
Right.
And that's where you need to have your decision maker weigh in on the propriety of the change order. But let's say it's holding up that work is going to really, really impact the schedule to the detriment of everyone. The construction change directive that you talked about before, Maria, is a document that directs, it doesn't have to be signed by both parties.
Right.
One party signs it and directs the work to continue with an agreement that the parties will figure out the cost or the schedule impact later. So there are different ways to modify what's in the original contract. Then that brings you, I think, to another incredibly important part of our construction project.
When we talk about risk, insurance becomes a very, very important part of this project. You want to make sure that, as an owner, you want to make sure that your contractor is adequately insured, because there can be problems. I've had sites where workers have been injured, where there was not adequate lighting in the hallways, and you want to make sure that they have their workers' compensation, they have all that. You want to make sure the insurance is at proper levels. How do you do that? There are a couple ways you can do that. You can, first of all, you should tell your owner client to talk to their insurance broker.
We are not insurance professionals.
Yes, you want to make sure they weigh in, but also states and cities provide information on minimum insurance requirements for contract projects, construction projects. So you want to make sure that you're at least meeting those minimums, but having the owner talk to their insurance broker is very, very important, because I've had sites burned down. I've had, so everyone then pulls out the insurance section, and so it's vital that you look into that.
So what types of insurance do you need for a construction project? Well, the contractor is required to have a certain amount of insurance and a certain type of insurance, and the owner
Yes.
also has insurance obligations. The contractor has to have general liability insurance, workers' comp, automobile coverage, and the contractor has to provide the owner with certificates of insurance showing that the owner is named as an additional insured.
Yes,
But-
and a certificate holder.
Right. And the owner also has to have insurance. So, in Maria's example of a fire that's burnt everything down, there has to be something called builder's risk
Yes.
insurance.
Yes.
And that is insurance that's typically purchased by the owner. And and the value of the policy has to be the total contract price. And that ensures that no matter what disaster that occurs, that the risk of building is covered.
And you also want to make sure that your owner realizes that their regular insurance, if they're, have now taken and done a big remodel of their home, that their regular insurance is going to insure the increased value.
Something I also always recommend in insurance portfolios for both contractors and owners is that, yes, you have to have the minimal types and the minimal levels of coverage that the state recommends. But I always also recommend an umbrella. An umbrella policy is exactly what it sounds like. It covers everything else that's not covered. So, and umbrella policies, the cost of umbrellas is typically a lot less than it is on a general liability policy or a builder's risk policy, but it provides necessary safeguards just to make sure everything is covered no matter what. So definitely ask your broker about umbrella policies. Now here's one of my favorites.
Yes, that's her area of expertise for
So-
sure.
So listen, let's say you did everything that Maria and I just recommended you do before the project and during construction, but you still end up with a dispute between the owner and the contractor. How is this addressed in the contract, and what can you do in the contract to minimize the impact on the project of a dispute? Well, we all know that disputes are horrible for both money and time. And those are the two, most important things on a construction project. So how do you handle disputes? Well, you lay it right out in the contract. And I always recommend, I'm going to guess Maria agrees, on having a multi-tiered dispute resolution process right in your construction contract. My favorite way of addressing disputes is I start with the very basics, because communication is key to a successful construction project. You must communicate with each other. So when I draft a dispute resolution clause, my first provision is, in the event of a dispute between the parties agree in this contract that the decision makers will sit down and have a good faith discussion in an attempt to resolve the dispute. Now, just because I'm a lawyer doesn't mean that I'm happy when my clients end up with disputes that require me to get involved. No. It's always better when the lawyers are not involved. So the project participants, the decision makers, the people who are on the ground, so to speak, need to get together and sit down and try to work things out before lawyers have to get involved.
Yes.
So that's the first thing that I recommend. After that, I recommend, again, another intermediate step. Let's not go straight after that, in the event that discussions are not successful in resolving the dispute. Most of the time they are, by the way. Sometimes, a lot of times when you
I
really,
agree with that.
and a lot of times I'll even include language that says in person. Forget a phone call, forget a Zoom call. get two people in a room and lock them in there and say, don't come out until you've worked it out.
Right, because the money should, and wanting to get the project done really does motivate people to be reasonable.
And when you're face to face with someone, it's a lot harder to be unreasonable. And it's really important to try to find a consensus on a path forward. But look, it's not always possible.
Right.
Sometimes you need even more help, but again, still short of litigation. How about mediation? Okay, the AIA form claims and disputes provision does include a provision for mediation as a prerequisite for arbitration or litigation.
Right.
You can't even proceed to a more formal dispute process until you go through the mediation process. And there's a good reason for this. Similar to the getting two people in a room, you get two people in a room, but you have a trained, neutral decision maker in the room that can help the parties see the pros and cons of their situation and assist them in seeing the perspective from the other side.
Right.
And help them to come to.
Yeah, hopefully get a solution out of that.
But again, not always possible.
Right.
And so you do have to go.
It's not a binding.
Right. Mediation is not binding. But the next step, look, unfortunately, it's true that at some point, conversations don't work, mediation doesn't work, and the parties are required to go to a binding dispute resolution process. In the contract, we include a clause that the parties, at the time of negotiation, can elect either arbitration or litigation. Arbitration is supposed to be a speedier, less expensive process for getting a determination on your dispute. Litigation, I tell my clients 1 to 3 years at best to get yourselves through a construction dispute. If you've got a complex construction project, something big, something technical, it could be 3 years plus. In getting to a resolution, and all you're doing at that point is spending a lot of money on legal fees.
Yes.
And that's to nobody's benefit except for the lawyers. And even though Marie and I are the lawyers, we don't consider that to be a successful result.
No.
We do it because we have to. Sometimes the parties really, really, are so differing in their evaluations of the situation that you have no choice. So arbitration before a neutral. The AIA form of standard construction contract calls for arbitration before the American Arbitration Association or a similar organization. The American Arbitration Association has a set of their own specific rules applicable to construction projects. And those rules were last amended in 2017. They're in the process of being amended again, and the AAA does take feedback from the people who use their processes to implement and to revise rules to make them user-friendly and to make them more effective. But in the AAA rules, you have a process by which the parties can agree on a single arbitrator or on 3 arbitrators.
3 arbitrators that's expensive.
It is.
We definitely push. I definitely push to 1 because I think 3 is just it's a huge expense.
I had a construction arbitration a number of years ago where the parties never modified the standard language of the AIA form, which called for 3. It was a disaster. So we needed to actually try the arbitration case. And I think ultimately it took about 8 trial days. But because we had 3 arbitrators and 2 lawyers to find 8 days that worked for everyone, it took about 9 months. And it was ridiculously expensive because we did 2 days, 1 month. So we ramped up, we prepared, we did 2 days of arbitration hearings, and then we stopped and we didn't come back to it for another 6 weeks, by which time everyone had to re-ramp up, refresh their recollections. The arbitrators themselves had to remember the testimony that they heard earlier. And then, so as I said, 8 days of arbitration took about 9 months and was outrageously expensive. So I do like to cut it down to one.
Definitely like to cut it down to one.
And in terms of who the arbitrator might be, the AAA has panels and panels of trained construction arbitrators. So these are professionals who go through rigorous training on how to assist in resolving disputes. And they are typically people in the construction industry. Sometimes they are lawyers, sometimes they're retired judges, sometimes they're architects or engineers. And I like to, in my arbitration clause, I like to specify who the arbitrator should be. I personally, in your run-of-the-mill construction dispute, like to have a retired judge. And why is that? Because they're used to making decisions.
Right.
They are professional decision makers. Retired judges have typically a lot of years under their belt of being an objective, third-party neutral, in being able to weigh the strengths and weaknesses, and then they have the legal expertise to determine the relative contractual strength of the parties' competing provisions. So that's why I like retired judges. But there are probably situations where you might want to have an engineer and architect instead, where the dispute is something very, very highly technical. So there, it might be very helpful to have a designer as your arbitrator. And then, of course, lawyers make good arbitrators as well. You know, especially when you have an experienced construction lawyer who either has retired from the practice of law and is doing arbitrations on the side, or someone who's just very experienced in supplementing their practice. But in that situation, you probably really want to look carefully to see if their practice is heavily owner or heavily contractor.
Right.
Because again, that will help you select the arbitrator that you think is best for your project. That will really help the parties see the disputes clearly and get to a resolution.
I think we've gone past our time, but one provision I just want to quickly highlight is the indemnity provision. You definitely want to make sure your construction contract has that. You want to make sure that you're dealing with losses, expenses, damages, costs, sort of everything you can throw in there as something. And definitely kind of arising out of the contractor's work, you know, that we definitely focus on, you know, bodily injury or harm to the property would be fully covered. It's important that that is in there in case of a problem on the lawsuit, on the project.
Right now, so we've tried to identify the lucky seven, the 7 most important provisions in a construction contract. But I think from the way that this discussion has gone today, it's become readily apparent that your construction contract has a lot of really key provisions. Marie and I have tried to select the ones that we think result in the most problems in litigation, so that you're aware of the provisions to pay special attention to in the course of negotiating and drafting your construction contract. But there's a lot of really important and very helpful provisions that can be included in construction contracts to manage the risk and help you get to a project that is within spec, on schedule, within budget, and available on both sides to pat themselves on the back for having successfully completed their construction contract. We're going to not take up any more of your time today because, as Maria said, I think we went over our 1 hour that we promised you. But are there any other questions? We'll take a look here. If not, thank you so much for listening to us today and talking about the lucky 7, the top 7 most important clauses for your construction contracts, and hope to see you next time.